If you're buying investment property with an LLC or a trust, there's a new federal reporting requirement that just went into effect on March 1st, 2026. And if you're paying cash or not getting traditional financing, your closing attorney or title company now has to report detailed information about you and your LLC to the federal government. Let me explain what this means and what you need to know. I'm Tiffany Weber, a real estate attorney here in North Carolina. I handle closings every single day, and starting March 1st, 2026, there's a brand new rule from FinCEN. That's the Financial Crimes Enforcement Network that affects how we report certain real estate transactions. In this video, I'm going to break down exactly what this new rule is, whether it applies to your transaction, what information gets reported, and what you need to do to prepare. By the end, you'll know exactly how this affects you if you're buying property with an LLC or trust. What is this new rule? So here's what happened. FinCEN issued a new rule called the Residential Real Estate Rule. It went into effect on March 1st, 2026, and what it does is require certain real estate professionals, like closing attorneys, title companies, and settlement agents, to file a report called a real estate report for specific types of transactions. Now, this isn't something you as the buyer have to file. Your closing attorney or title company files it, but you do need to provide information to them so they can complete the report. And if you don't provide that information, your closing could get delayed or the attorney might refuse to close the transaction. So let's talk about when this rule applies. The rule applies when all four of these conditions are met. Condition number one, it's residential real property. That means a townhouse, house, condo, co-op, or vacant land where you intend to build a home designed for 1 to 4 families. So single family homes, duplexes, triplexes, fourplexes, all covered. If you're buying a large apartment building designed for more than 4 families, or you're buying commercial property, this rule doesn't apply. Condition number 2 is that the buyer is a legal entity or trust. This is the big one. If you're buying the property in your personal name, just you as an individual, this rule doesn't apply. But if you're buying it with an LLC, a corporation, a partnership, or certain types of trust, then it does apply. Now, there are some exceptions if your LLC is a publicly traded company, or if it's a bank or a credit union, you're exempt. But for most investors using a standard LLC, you're going to be subject to this rule. Condition number 3 is if it's a non-financed transfer. This means you're paying cash or you're getting financing from a lender that doesn't have anti-money laundering regulations. So if you're getting a traditional mortgage from a bank or a credit union, this rule doesn't apply. Banks already have to report suspicious activity, so FinCEN isn't worried about those transactions. But if you're paying all cash, or you're getting seller financing, or you're getting a loan from a private lender or hard money lender that doesn't have those reporting obligations, then this rule applies. Condition number 4 is no exemption applies. There are several exemptions. For example, if you're transferring property because of a divorce or because someone died, or if it's supervised by a court, those transfers are exempt. Also, if you're transferring property to a qualified intermediary for a 1031 exchange, that specific transfer is exempt. But when the property comes out of the exchange and goes to your LLC, that transfer might be reportable. Those are the 4 conditions. If all 4 are met, your closing professional has to file a real estate report. What information gets reported? Okay, so let's say your transaction is reportable. What information does your closing attorney have to report to FinCEN? Here's what they need. About the property, they need to report the street address and the legal description, including the lot, block, and section. And then about your LLC or trust, that would be the full legal name, the principal place of business address, a tax ID number, the total purchase price. And then about the beneficial owners. This is the part that surprises people. The government wants to know who actually owns and controls your LLC or trust. If you're using an LLC, they want to know every individual who either owns 25% or more of the LLC or exercises substantial control over the LLC. So if you own 100% of your LLC, that's you. If you and your spouse each own 50%, that's both of you. If you have 3 partners who each own a third, that's all 3 of you. For each beneficial owner, your closing attorney has to report their full legal name, date of birth, current residential address, a unique identifying number, so that's usually your social security number, and then about signing individuals. They also have to report information about anyone who signed documents on behalf of your LLC at closing. So if you're the manager of your LLC and you sign the deed, they report your information as a signing individual. About payments, they have to report how you paid for the property. If you wired money from a bank account, they report the bank name and account number. If you paid with a cashier's check, they report that information. Now here's something important. If the money came from an escrow account or trust account held for the benefit of your LLC, they don't have to report the underlying source. But if you wired money directly from your personal account or your LLC's operating account, that gets reported. Now, who files the report? You don't file it as a buyer or seller. Your closing professional does. There's something called a reporting cascade that determines who's responsible. And basically, it goes in this order. So there's the closing or settlement agent listed on the settlement statement. There's no settlement agent, then it's the person who prepares the settlement statement. If there's no settlement statement, it's the person who files the deed with the county. Could be the title insurance company, and so on down the list. In North Carolina, it's usually going to be your closing attorney or the title company. But whoever it is, they're the ones responsible for filing the report within 30 to 60 days after closing, depending on the time of the closing. What do you need to do? Here's what you need to know as a buyer. Step 1, expect to provide additional information. Your closing attorney is going to ask you for information they didn't used to ask for. They're going to need the names, dates of birth, and addresses of everyone who owns 25% or more of your LLC, social security numbers or passport numbers for those individuals, information about how you're paying for the property. This is not optional. If you don't provide it, your attorney can't close the transaction. They could face penalties if they file an incomplete report or fail to file the report. Step 2, be prepared to certify the information. Your attorney is going to ask you to sign a certification saying that the information you provided is accurate to the best of your knowledge. They're allowed to rely on what you tell them as long as you certify it in writing. Step 3, understand that this is confidential. The information reported to FinCEN is not public. It's stored in a secure database and is only accessible to law enforcement and certain government agencies. It is not like a deed that anyone can look up at the courthouse or register of deeds. The goal of this rule is to combat money laundering. The government wants to know who's really buying property when it's purchased through an LLC, especially in all cash deals, because those transactions have historically been used to launder money. If you're a legitimate investor, this is just a compliance requirement. It's not going to affect your privacy in any meaningful way beyond what's already reported. What if you don't want to provide this information? Here's the reality. If you don't want to provide the required information, you have a few options. Option 1 is buy the property in your personal name instead of an LLC. If you buy it as an individual, this rule doesn't apply. Of course, you lose the liability protections and other benefits of using an LLC, but that's a choice you can make. Option 2 is get traditional financing. If you get a mortgage from a bank or credit union, this rule doesn't apply. The bank already has anti-money laundering obligations, so FinCEN doesn't require the additional reporting. And option 3 is don't close the transaction. If you refuse to provide the information and your attorney can't file a complete report, they're probably not going to close the deal. They could face penalties for filing an incomplete report or not filing at all. Those are your options. But honestly, if you're a legitimate investor, providing this information shouldn't be a huge deal. It's similar to what you'd provide when opening a bank account for your LLC. Now, does this apply to properties you already own? No. This rule only applies to transactions that close on or after March 1st, 2026. If you'd have bought a property with your LLC last year or 5 years ago, you don't have to go back and report that. This is only for new transactions or transfers going forward. Here's some common questions. So what if I'm buying multiple properties at once? If you're buying multiple properties in one transaction, like a developer buying several lots, your attorney files one report and lists all of the properties. If you're buying them in separate transactions, they file separate reports. What if my LLC is owned by another LLC? The rule requires reporting the individual beneficial owners. So if your LLC is owned by another LLC, you have to identify the individuals who ultimately own and control that parent LLC. What if I'm using a trust? If you're buying property with a trust, the reporting requirements may be a little different. Your attorney has to report the trustee, any beneficiaries who have certain rights, and the grantor if the trust is revocable. If you're using a trust, definitely talk to your attorney about what information they'll need. To recap, if you are buying residential real estate in North Carolina with an LLC or trust or other entity, and you're paying cash or using non-traditional financing, your closing attorney has to file a real estate report with FinCEN starting March 1st, 2026. They'll need information about your beneficial owners, how you're paying, and who's signing documents. This is a federal requirement, and if you don't provide the information, your closing could be delayed. If you're buying property with an LLC and have questions about how this affects you, and you're in North Carolina, I can help. Link in the description to schedule a consultation. I'll walk you through exactly what you need to provide and make sure your closing goes smoothly. And if you're a realtor who needs to understand this rule so you can explain it to your clients, I made a separate video just for you. I'll link to that in the description. Thanks for watching, and subscribe for more real estate content that actually makes sense. Check out this video next where I explain what realtors need to know about the new FinCEN rule.